Good day, and thank you for joining us for today's Seminar Web Live program, Maximizing Settlement Benefits and Minimizing Risks, Essential Strategies for Plaintiff Attorneys. During the live program, silent attendance prompts will appear on your screen. These prompts are not active in the recorded version of this program. For the live seminar, these prompts may be required for CLE credit in your jurisdiction. You'll have approximately 15 seconds to respond to these prompts. You may submit questions over the web throughout the program by typing them into the Q&A section, and we will address those at the end of today's program. Our speaker today is Joanna Wynes. Joanna is a licensed attorney in good standing in Pennsylvania, licensed structured settlement producer practicing around the country, and president of the American Association of Settlement Consultants. I will now turn the presentation over to our speaker. Please go ahead.
Thank you so much, Aubrey, and thank you, Seminar Web, for the opportunity. Just to elaborate a little bit more on what Aubrey discussed, I used to be a litigator in Philadelphia handling catastrophic medical malpractice actions. I moved down to Maryland in 2014 at the beginning of 2016, I became a settlement consultant. I know how hard probably everyone here works to get your clients the settlements that you do. And I feel like it's my job and my duty to help your clients try to thrive in the face of adversity. Today, in my presentation, I'm going to focus on topics such as government benefits, special needs trusts, protecting Medicare's future interests, and structured settlements, as well as attorney fee deferrals. I've presented nationally on all these topics. I've spent hours talking on really each individual topic. But today, with the hour that we have allotted, I really wanted to give everyone a good overview to help maximize your client settlements, to protect your clients and your firm. And really, in focusing this content, I was thinking about some success stories, some cautionary tales, panicked phone calls that I get from attorneys, or panicked LinkedIn messages that I get from attorneys at 8, 9 o'clock at night, and frequently asked questions that I get through various trial lawyer listservs and through phone calls. So I appreciate your time today, and again, drop any questions that you have in the chat, or I'm sorry, in the Q&A, and I will respond to them as soon as this is over. So, settlement planning, why does it matter? Before I really get into the technical nitty-gritty, I really wanted to share with all of you some wise words that regarding planning, and these are things that influence me daily, personally and professionally, and I always keep these things at the forefront of my mind when I'm working with the clients. So when we talk about planning, there's several different aspects, and it's obviously important to have a plan. Goal achievement. Our goals can only be achieved through a vehicle of plan in which we fervently believe and upon which we must vigorously act. There's no other route to success. That was Pablo Picasso. Direction. If you don't know where you're going, you'll end up someplace else. Yogi Berra. Long-term vision. Someone's sitting in the shade today because someone planted a tree a long time ago. And that's from Warren Buffett. And I know some of these concepts seem simple, but we're all working with clients who are, in very, very vulnerable situations. And in my experience, a lot of the people that I work with, they're really in survival mode. They are trying to put food on their tables. A lot of them are housing insecure. They don't necessarily even have working cell phones. They don't know how to use computers. Sometimes they've never, paid a bill online. They've never had steady income. They don't have anyone around them as a positive influence. And I think, when working with people in that situation, when you're focusing on surviving day to day, it's really hard to have that long-term vision. So it's really important when a client is getting a settlement that we have a plan and we look at the funds that we have available, look at available government resources and different tools to really maximize what they're getting in their pocket and make sure that the settlement that you are working so hard to achieve goes for the intended purposes. And obviously, our settlement values across the country range significantly. Some jurisdictions have caps, some don't. In my experience, it's almost harder, or I guess a lot of people think that settlement planning is utilized in these really catastrophic bad baby cases and brain injury cases. And of course, we use these tools in those cases all the time. But some of these tools become even more critical when you're dealing with somebody who has these very extensive lifetime needs, or, these really difficult situations. And the money might not be enough to really get there without a proper plan. So I always want to sit down with a client and talk to them and ask them what their goals are. A lot of them just want to get out of the situation they're in right now. And we just try to we look at the funds available, and we want to come up with something that will reach that goal. And if the goals that the clients have, sometimes I do have clients who really desperately want to buy a home and there's just really not enough funds, then at least we can kind of go through that and talk about some alternatives, and other ways to accomplish things that they want to accomplish. So that is why, in my opinion, settlement planning matters. Now, get into a little bit more of the technicalities. So settlement planning, what is it? A large aspect of it, as I mentioned, is government benefits assessment and preservation planning. So this means we want to see what available government resources are there for the client. Is your client eligible for SSI? Are they eligible for SSDI? Is your client on Medicare? Is your client on Medicaid? Are they eligible for one of those benefit categories or another? Or are they dual eligible? And I do have clients all the time who are on Medicare, Medicaid, SSI, and SSDI. I have some clients who are just on SSI and Medicaid. I have some clients who are on SSDI and Medicare. I have some people who don't get SSI. Children with brain injuries and their families are getting very extensive Medicaid services around the clock. And all of these different types of benefit categories, as you'll see, and as I'll get into in more depth in a little bit, they have different mechanisms for protection and different things that we have to do. So that's a very large part of what I do. Structured settlements and wealth management assistance, and we'll go into some of the different times when structured settlements can be beneficial for your client and the ways to ensure a very smooth process in that regard. I'll also talk about special needs trust planning. I do some of this on my own. I work with a lot of pooled special needs trusts, also collaborate often with elder law attorneys in various jurisdictions across the country. And I will say in this presentation, obviously it's given to a national audience. And so I will address a lot of the federal benefits, but Medicaid can get very state specific as far as the nuance. So I do want to give that caveat. And then coordination with nurse case managers, if that's appropriate in the case. And what I mean by that is sometimes there are nurse case management companies, sometimes they are life care planners who have a different division, or sometimes there's just companies that help clients apply for benefits. But sometimes I find bringing these nurse case managers on are extremely helpful. If I have a client who is in a nursing home facility and they want to move home, and Medicaid is currently paying for their facility that they're living in, sometimes I'll call in a nurse case manager and have them do a full assessment and see if there is another Medicaid program that the person might be eligible for in their state that would allow them to come home and get some home care. So I'll sometimes talk with nurse case managers and find out, what type of program would this person be eligible for? Also, if the person is eligible for some sort of Medicaid program where maybe they are getting attendant care, we want to know how many hours would they be eligible for? How much can we expect the government to pay for if we set everything up the right way? And doing that really does help figure out how we should set up the money, how we should set up a structure, how we should set up a special needs trust, because we need to really first find what is the actual appropriate placement for this person and can we make it work? I'm working on a case right now with an individual who is housing insecure, quadriplegic on SSI. And his settlement, because of liability issues, is a mid-six-figure settlement. And we really, really, really need this to take care of him for his whole life. He hates the facility that he's living in right now. he ideally would love to purchase a home and staff it with round-the-clock care, private pay, but there's really just not enough funds there for that. So we brought on a nurse case manager to help find better facilities, to see, is there companion care that we can provide this gentleman? And how much would that cost? And then we can really look at the numbers and properly allocate between a structured settlement and a special needs trust, maximize the Medicaid benefits he might be able to get through the government while using the settlement dollars to really boost up that level of care for him. So I find that really in some of those catastrophic cases, again, especially when there's movement from a facility to out of the facility, or really the client doesn't know, they're not yet on benefits, but they should be, they can be really, really helpful. So for plaintiff attorneys, what is the value of settlement planning? Well, first and foremost, you know that your clients will be protected. We can do case value assessments. So looking at life care plans and sort of maybe working with a nurse case manager to figure out, what do we actually need to be able to fulfill the goals of the life care plan. We can send out structured settlement proposals showing what it would cost to fund the life care plan, to help attorneys sort of in the background do some assessment as to what an acceptable settlement range might be. Now, obviously, I'm not the one who is ever deciding that or telling anyone what to do. That's the attorney's job. But to the extent that we can help provide data to provide an informed decision, I find that that's very helpful. Go into lien resolution. I am not a lien expert. I've worked with lien experts, but I highly recommend, either engaging a lien company or starting the lien resolution process early, because I think as everyone on this seminar probably knows, liens can really jam things up at the end of settlement if we're not prepared. And again, I know a lot of attorneys prefer to do these things in-house, and some do prefer to outsource. I'd say if you do outsource, do it as early as possible, because the outsource companies, they're not charging hourly. So get everything teed up, have your arguments teed up, have the case ready to go so that when things settle, you're ready to make the arguments and hopefully get the lien resolved quickly. Legal malpractice avoidance. I think that there are a lot of people who do believe that once they get the funds, that it's the client's decision. The attorney doesn't have to provide further input, and they just kind of want to be hands off and move on to the next case. And I completely understand that. But sometimes this doesn't end up working for the best. I'm also working on a case right now where one of my very valued firms, got a case. It's a legal malpractice case, and it's involving a baby with a severe brain injury. I don't even know who handled the underlying action, to be honest. But this brain injured child, instead of protecting the right to get government benefits or doing a structured settlement, they sent the funds to the default account in Maryland, which is called our Title 13 account. And it probably operates similarly to registries of courts and block minors accounts in other jurisdictions, where the money really can't be touched without a court order. It can't gain interest. And, the minor, when they turn 18, can just get those funds. It also does not protect government benefits. And so the subsequent attorney investigating the legal malpractice case asked me if there was anything that I could do to try to help the family or mitigate the damages of the fact that, a 3-year-old's several $100,000 was just going to sit for 15 years and his parents wouldn't be able to get those benefits. And so because the minor did have special needs, we did petition the court to have the funds moved from this restricted account into a special needs trust. So now the family is eligible for the government benefits. We can't do a structured settlement. And again, I'll talk more about the technicalities of structures in a little bit. But at least now they're getting some investment. They're getting, some money management and oversight and that protection. We also might end up purchasing a retail annuity within the trust to help maximize the guaranteed return for this child. But again, that's something, the family was obviously devastated when they found out that there were other options that weren't made available to them. I've had families call me after they get a check for a couple $100,000 and say, hey, can you help me structure this? And at that point, I can't do anything. And so again, when people find out that they could have had a tax-free guaranteed return, and significant interest gained on their child's money, and that opportunity is lost, it is difficult. It's really difficult. So then I'm going to go talk about attorney fee structures just a little bit. And that's more of a benefit to you all versus your clients, but attorneys handling personal injury actions and other contingency fee actions are able to structure and defer their fees in various ways. And this can help significantly with tax planning. So that's something I'll touch on again later. Then assistance with court-approved settlements and minor compromise petitions. Anytime I'm involved in a case that involves a minor's compromise, we will help provide language for the court order, make sure that, there's a trust ready to be attached, that you have everything that you need, and, that it is ready to go without issue. We also testify if we have to in minor's compromise petitions, and we really are just there to support that process. Okay. So I want to talk about things to help make the settlement process more efficient and better for everyone. One of the things that I see often is clients haven't applied for disability benefits or SSI benefits or Medicaid throughout the litigation process. I've seen this for different reasons, but sometimes I do honestly have attorneys saying, I'm scared. I don't want my clients to apply for these benefits because I don't know what that will do to the settlement. Sometimes I have clients who, they just have a lot of pride and they're like, I don't want to live off of the government's dime if I don't have to, and I want to get my settlement. And they're too proud, and I understand all of these different angles. But when clients get the benefits that they are eligible for early on in the process, they're not so desperate when they come to settlement, right? They're not, maybe now they at least have $30,000 a year of income coming in. They're not lawsuit loaned up to their eyeballs. They don't have to pay all their family members back from their settlements because the government has been helping them along the way. So again, another thing about that is when I have clients who know they need government benefits, but they're not entirely sure whether they are eligible for SSI or SSDI based on their working history, it really does jam things up during settlement because, as you'll see, different benefit categories do have these different protective mechanisms. And without knowing what they are actually eligible for, it's harder to tell them very concretely, this is what you should use, this is what you shouldn't use. And sometimes people are eligible for a combination of SSI and SSDI, like I said earlier. SSI, as we'll discuss later, does require special needs trust. SSDI does not. So Medicare has very different consequences than Medicaid. So knowing these benefits and identifying them and making sure the client is already on them at the time of settlement, if they are eligible and if that is something that is useful for them and will help, that they get on those benefits, because it really will make things easier at the end of settlement. Again, evaluate these government benefits and public resources, because if you have a Medicaid home waiver, and some of my babies who I work with who have, severe brain injuries are getting 12 hours a day of care paid for through Medicaid. And that's invaluable. The cost, or the amount it would cost to fund that privately, is really astronomical and beyond what, a lot of our personal injury victims get, especially in jurisdictions that have caps. And lien resolution and verification. I would recommend when you sign up a case, ask your client for their insurance cards. Find out, are they on Medicare? Are they on Medicaid? Who is their lien holder? And again, if you do decide to engage a lien resolution specialist, do that early. If you do this in-house, start the process early, because waiting till the end is not going to necessarily help things. And then setting expectations. I have been involved in so many calls where somebody's been they've been a claimant in a case for 3 or 4 years and they're getting their settlement and they think they're going to just get handed a lump sum, or they think they're going to be handed a lump sum for their baby. And they're on SSI, or, again, it's a minor and there's minors laws. And the clients are hearing this from me for the first time after they're expecting this lump sum and they have all these great plans. And the conversation at that point in time is very, very, very difficult to have. The clients are usually a little bit in shock. They're like, why didn't I know this earlier? So again, please, if you have clients that are on these benefits, you don't have to talk numbers. We don't want to, set false hope or anything like that, or anchor them to a specific number, but just let them know that if they are on these benefits, there are some things that we'll have to deal with at settlement. And if they have questions early on in the process about it, myself or your settlement consultant or an elder law attorney, we can do these consults with them earlier on in the process, again, to set expectations. And so they haven't already spent the money and have all these huge plans in their heads that really can never legally be accomplished. So now we're going to talk a little bit about the various benefit categories and settlement planning. So we have entitlements and we have the government assisted benefits. And I'm going to really talk about these in the personal injury and wrongful death context. I'm not going to go into too deep of a dive in workers' compensation. I don't know how many workers' compensation attorneys are on this, but some of the rules and how things work are different in workers' compensation cases, especially SSDI and Medicare. So with entitlements, these are the earned benefits. These are not means tested. You paid into it on your paycheck. You're entitled to these. These benefits in and of themselves don't require a special needs trust. However, like I said, always be mindful of protecting Medicare's future interests. And while I said I'm not going to talk about workers' compensation cases, do be mindful that if you have a client who is on SSDI and they are receiving a workers' compensation settlement, sometimes there is an offset. That offset cannot be mitigated through a special needs trust, but there's different ways to present the language in the settlement agreement according to PALM's guidelines to help mitigate the impact of that offset on the workers' compensation settlement. So again, the entitlements, we have SSDI, we have Social Security retirement 65 or over. We have Medicare. If the person's under 65, it's because they've received SSDI for 24 months or they're over 65 years old. Then we have our government-assisted needs-based benefits. SSI, that is, so supplemental security income is the type of disability income that our clients get when they have not paid enough credits into the Social Security system. A lot of the babies who have birth injuries, obviously they never work. They're never going to be able to work, unfortunately. And so those would be recipients of SSI. We have lots of clients who, they might have bipolar disorder, they're autistic, depression, anxiety, things like that. Those clients, again, often they're on SSI because some of these disabilities manifest, in early adulthood or childhood, and it really impacts their working history. SSI is the current SSI amount is $943 a month. So keep note of that. So if you have a client and they tell you that they are on SSDI and you ask them how much money they're getting and they say that they're getting $943, it's probably SSI. Attorney tip, it is very, in my experience, it is safest to get the award letter directly from Social Security unless you have a client that knows for sure they're on SSI or they know exactly what they are getting, because a lot of clients have no idea what type of Social Security they're getting. They don't know if it is SSI, they don't know if it's SSDI, they don't know if it's a combination. So getting the documentation directly from the government is a good move. Medicaid. I'm going to show you a little flow chart in just a bit. Medicaid can get confusing. That is a government-assisted needs-based benefit. There are many, many, many different kinds of Medicaid. Some Medicaids do require a special needs trust for protection. Others do not. In Maryland, for example, and again, that's a state that I do a ton of work in. I do work in Texas. I do work in Delaware, New Jersey, Minnesota, really Virginia, DC, across the country. But I do happen to work a lot in Maryland. So Maryland and a lot of these other states, we have what's called MAGI Medicaid, and we have non-MAGI Medicaid. MAGI stands for Modified Adjusted Gross Income Medicaid. When I have a client who is simply low income but not disabled, they are usually on Modified Adjusted Gross Income Medicaid. That type of Medicaid does not have an asset test. A settlement is considered an asset except for in the month that it is received, in which it can be considered income. But then thereafter, it just stays as an asset. So when people have this MAGI Medicaid and they're not disabled, we can't do a special needs trust and we don't need to do a special needs trust. However, there are many other categories where we absolutely need some sort of protective mechanism. I do not know the California laws. I know things have just recently changed as far as how to protect different types of Medicaid. So again, if you have state-specific questions, do talk to your local consultant or a Medicaid expert or an elder law attorney. Or if you do need to contact me, feel free to do so, and I can help you get the most accurate information for your jurisdiction. But if you have a client who is in long-term care, they're in a nursing home, often they do have this means-tested non-MAGI Medicaid that would require a special needs trust. The home care clients on SSI who are on Medicaid and SSI, again, they do need special needs trust or some other protective mechanism. Then we have Section 8 housing, and we also have food stamps. So those are things that we need to address and explore and just determine whether these need protection or whether these are benefits that the clients actually do want to protect. And so now we're going to go to identifying benefits. And this sort of is a hopefully helpful chart for everyone to help sort of issue spot. But to start, is your client disabled or are they receiving income from Social Security? And if the answer is no, then they usually would have income-based Medicaid, which wouldn't need a special needs trust. Again, if you have very specific questions, talk to somebody local in your jurisdiction, or we can do research or talk about state-specific issues. If the client is disabled and they are receiving Social Security, we want to know how much is that person receiving. And if it's $943 or less, as I just said, then we're looking at SSI, which does need a special needs trust. If we're looking at more than $943 per month, they're likely on SSDI or retirement income plus Medicare. And then we have to look, is the client receiving Medicaid there? And if the answer is no, then we don't need a special needs trust. And if the answer is yes, then it's very likely means tested, and we will need a special needs trust or other sort of protective mechanism. Okay. So I do special needs consults often, and one of the most common questions I get is, what can we use the special needs trust for? So I have this, it's a pretty good overview of permissible and restrictive expenses. A lot of attorneys or a lot of people seem to be under the impression that special needs trusts are for special needs, just for the special needs expenses, but it's almost the opposite. They're really for anything that will help enhance the life of the injury victim. The trusts are not supposed to be used for anything that should be paid for with a government benefit. So we'll look at this non-permitted or this impermissible section. Some of these, as I said, distributions won't be made if they're determined that the payment would adversely affect the beneficiary's eligibility for services or supports. Right now, something super unfortunate is that if you're on SSI and you want to get a distribution from your trust to help pay for rent or gas and electric, groceries, water, sewer, those very, very basic expenses. If the trust makes distributions for those things, that $943 per month gets reduced by a third. Sometimes, it's a risk benefit analysis. Is it worth it for the client to get more money from their trust and less money outside of the trust? And that has to be determined on a case-by-case basis. When I'm talking about some of these impermissible expenses, though, I want to bring up ABLE accounts. An ABLE account is a tool that sometimes we use in conjunction with special needs trusts. It's an Achieving Better Life Experience Act. And the ABLE account currently is for individuals who are disabled prior to the age of 26. It doesn't matter when they're receiving their settlement, but they have to be disabled prior to the age of 26. And instead of instead of having to get all their funds through the special needs trust can fund an ABLE account to pay for some of these not permitted expenses. They can contribute up to $18,000 per year to an ABLE account without jeopardizing benefits. And the ABLE account can have a maximum of $100,000 in it before it jeopardizes the beneficiary's eligibility. So what I often have happen is I will have the special needs trust distribute about $1,500 a month into an ABLE account to help the families where they can use the ABLE account for the rent and the gas and electric, and then their Social Security stays intact. Now, food and groceries are on here now, but good news is, as of, I believe it's September 30th of 2024, Social Security is no longer going to place these restrictions on groceries, which I think will be really helpful for a lot of our clients, because food is obviously important, and $943 in this day and age, as we all know, is really not sufficient to help pay for food, housing, and these basic needs. So when we can use those tools together, I always try to do that if it's going to work out, in the best interest of the client. Now, like I said, the onset of disability as of now has to be prior to 26. At the beginning of January of, I believe it's 2026, the age is going to be raised to 46. So I think that's going to be helpful for a lot more individuals. And again, it really, I think, makes the special needs trust a little bit more user-friendly, because then the clients can have their basic needs met, as well as some of these luxuries like travel, getting their hair done, getting housekeeping services, pet care, things like that, going on vacations. Then the trust can really, help with those types of benefits. Okay. So now I am going to talk about a topic that I think raises a lot of fear, and causes a lot of frustration, both in the settlement industry and the legal industry alike, and that is protecting Medicare's future interest. Should we do a Medicare set-aside? If we shouldn't, what should we do instead? When should we consider a set-aside? When do we not even need to have that enter into the conversation? So right now, there's a lot of guidance in workers' compensation cases. We don't have that in liability cases. So currently we have no clear guidance from CMS on how they envision the roles of Medicare set-asides in liability cases. They have been suggesting for years that this guidance is going to come. And it's really crazy because I remember sitting in the kitchen of the law firm that I worked at in 2009, and I heard about Medicare set-asides for the first time. And I just thought, my gosh, how are we ever going to settle cases if we have to fund all of this future care? If all of our life care plan just ends up going into a set-aside, then cases will be unsettlable. That has not happened. And I'll show later some examples of the fact that if it is a case where a Medicare set-aside might be in your client's best interest, they don't impact the settlements, I think, as significantly as people might believe. And I'll go into that, like I said, in a little bit more detail. But right now, under the Medicare Secondary Payer Act, Medicare is generally precluded from paying the beneficiary's medical expenses when payment has been made or can reasonably be expected to be made under a workers' compensation plan, an automobile or liability insurance policy, or no-fault insurance. And again, Medicare has enforced these restrictions in workers' compensation cases. We don't yet have data as far as whether they are or how often they are actually enforcing these provisions in liability cases. So in my sort of the industry consensus is we want to protect, we know we need to do something to protect Medicare's interests. What each of your firms do is sort of, there's a lot of risk tolerance between you and your clients, but make sure you know when you should at least be having these conversations with the clients versus when you don't need to think about it. And make sure the clients are informed and that it's their decision at the end of the day, whether they want to set something aside or whether they want to take the risks that happen if they don't do a set aside and it's recommended. I did a presentation almost exactly 2 years ago for over an hour just on this topic. So if anyone wants that PowerPoint, feel free to email me after. I'm happy to share that. I also just got a really helpful flow chart last night from an industry colleague, and I found that to be really helpful. So it's sort of, it was just recently put together, but if anyone wants to see that, I'm happy to share that as well. But again, what authority, where does this Medicare guidance even come from? And there was this Stalcup memo, CMS regional coordinator pronouncement. We urge counsel to consider the issue in settling the case and recommend that their determination as to whether or not the case provided recovery funds for future medicals be documented in their records. Should they determine that future services are funded, these dollars must be used to pay for future otherwise Medicare covered case related expenses. And we have to consider this in the liability context as well as in the workers' compensation context. So you'll ask, are MSAs required in liability cases? Medicare set-asides are not mandatory at this time. However, settlements that are closing out future injury-related treatment should avoid cost shifting the post-settlement injury-related care onto Medicare. A Medicare set-aside is one preferred method of avoiding this cost shift. So again, a Medicare set-aside is a risk management tool for your practice and for your clients. Attorneys will say, should I do a Medicare set-aside in this case that I'm calling you about? So these are three really important questions. Is the claimant or plaintiff currently a Medicare beneficiary, or are they Medicare eligible? And if the answer is no, again, in these birth injury cases, for example, these babies are not going to be Medicare eligible anytime soon. So in those cases, we really don't worry about it. The second question is, does the plaintiff require future medical treatment? If you can get a treating physician to certify that the client does not need any future injury-related treatment, that can be very, very helpful. Now, DMEs don't work because, as we know, the defense loves to say that our clients are not injured and they don't need any future treatment. But if you can get an actual treating physician to opine that they don't need future medical related treatment, that is very, very helpful. And then we look, does the settlement fund future medicals? So, some of these very low dollar cases, they really are not funding future medicals. But sort of the framework that I operate under is, again, if the responses to all these questions are no, I'll advise that there's not likely a cost shift to Medicare. If the responses to all these questions are yes, then I do suggest that the attorney seek an allocation, and there's wonderful nurse allocators and allocation companies across the country that can help do that. I used to draft MSAs. I'm very, very fortunate that I no longer do that. But there's really wonderful, dedicated people who do this all day, every day. And then if the answer to the first question is yes, but the other responses are unclear, then again, I recommend speaking to somebody who does these Medicare consults all day, every day to determine, can there be an opinion letter as to maybe why Medicare or why a Medicare set-aside is not necessary? Or maybe it seems to your office and the allocator that doing a Medicare set-aside is in your client's best interest, but your client says, I'm willing to take the risk because I don't think that Medicare is ever going to enforce this. Then you can get a waiver or, a release showing that you did educate your clients on these options and they just decided to take the settlement in a lump sum. When we are talking about Medicare set-aside, though, one thing that I do want to bring up is this is entirely a plaintiff issue and a plaintiff attorney issue. Unlike paying Medicare's conditional payment, which does involve the carrier and where everyone can be on the hook if a conditional payment, if a final demand is not paid back, Medicare set-asides are not a defense issue. There are some carriers I've seen who do try to enforce that, or they say they won't settle the cases unless a Medicare set-aside is done. They should not be doing that, but nonetheless, it does happen. And I'd recommend if you are in a situation where the carrier is doing that and they do an allocation, hire your own allocator to do your own allocation, because these allocations can very much vary from allocator to allocator. Some people are more conservative, some people are a little bit more risky, some of the set-asides are larger, some of them are smaller. And again, because CMS is not going to review them in these liability cases, it's still kind of the wild west. And it's important for you to do what seems like is in the best interest of your firm and your client. And so when I do get to the point where I have an attorney who feels like it probably is in their client's best interest to at least recommend a set-aside, I do have a lot of people who are afraid that this MSA is going to blow up their entire settlement. And I always tell people, no, we will make it work. And I've had some cases where we have massive life care plans. And I'm going to show a case example very shortly, but I've had these cases where we have massive life care plans and there's tons of attendant care. The attendant care that I was talking about with Medicaid before, that is not paid for by Medicare. So that would automatically come off the top. That would not be included in a Medicare set-aside. Medicare set-asides also, instead of just using the regular straight life expectancy of the client, they use a rated life expectancy. So the allocators will submit medical records to an underwriting company, and the underwriting company will then go look at all of your client's medical conditions and say, yes, their normal life expectancy is 20 years, but because of X, Y, and Z, they're only anticipated to live another 10 years. And then instead of projecting the expenses over the 20-year period, they're now going to project them over that 10-year period. And then there's reduction analyses that are done for procurement costs and expenses. And then we can also fund, if the Medicare set-aside is still big, after, you chop down all these things, then we can also still fund it. We can fund it with a structured settlement for cost savings. I'll say I do have attorneys request set-asides often. In my experience, other than these organ failure cases, and that is one that I'm going to present, the set-asides at the end of the day generally do end up being fairly nominal. Again, nobody wants to put their money aside. People want to have the money available to them to buy cars and take trips, take care of their families. But in the event that we are doing a set-aside, we want to minimize the impact of that on the client settlement as much as possible while still providing that protection. But actually, I'm sorry, before I go on to structured settlements, I do want to talk about this case study. So I worked on a case a couple of years ago, and I was working with a 63-year-old male. His life expectancy was, or standard life expectancy was 19.4 years at the time. We got a rated life expectancy of 11 years. He was a Medicare beneficiary. He required an organ transplant. His life care plan, even at the age of 63, was it was over $22 million, with $20 million of that being his medications. The case settled for $7 million, which was a phenomenal settlement, especially in this capped jurisdiction. Now, he was on two very, very, very expensive medications. And one of the medications at the time of settlement, he wasn't sure that he was going to continue. He was trying to sort of wean off of it at that time. And so what we did was we had the Medicare Set-Aside allocator at the attorney's request and at the client's request prepare an allocation, both including that one medication and one without that one specific medication, but just the other expensive one. So the liability Medicare Set-Aside with both of the very expensive medications included was $10 million. And again, the settlement was $7 million. But this is a success story, so stick with me. So then we did another LMSA without that one medication, but with the other included. And that turned out to be $4,389,000. The client and the attorney and talking to the doctors and seeing where he was at that time, decided that they did not want to include that medication in the set-aside because the client really did not anticipate that he would continue on that drug. So what we did, then we did a reduction calculation off of that $4,389,959. We looked at the full case value, which we got from the attorney, which was the non-economic cap, where it was, plus the economic damages. So the full case value there was over $23 million. The client was netting approximately $3.5 million after liens, attorney's fees, and costs. So he recovered about 15% of the full value of the settlement. So we took that $4 million and we set aside $662,000, which was 15% of that, out of the $3.5 million that he was going to net. But what we did, for a Medicare set-aside, you can either fund that with a lump sum or you can fund it with a structured settlement. And there's a certain formula that we're supposed to use when we do that. And so in this case, we did fund, we put what was called the seed money. So that was the first 2 years of treatment, plus the first medical procedure. And that was $120,000 for the seed money. And then the structured settlement cost $445,494 to fund. So at the end of the day, he put $566,000 of his settlement towards a Medicare set-aside. But again, this was a case where somebody had catastrophic injuries, needed very extensive Medicare treatment. Medicare is on notice of the claim because they've been put on notice of the claim through the conditional summary, through resolving the conditional payments final demand. Sort of the consensus is industry-wide that if Medicare is ever going to go after somebody in the liability context, it's going to be a large settlement. It's going to be somebody that is requiring a ton of Medicare future injury-related treatment. And it's going to be a situation where, Medicare is already aware of these injuries because it's a little bit easier to sort of see the ICD-10 codes and CPT codes and flag them in that situation. So that's why we did a really robust one there. But even so, we're looking at a $22 million life care plan with all 22 million of those expenses in this case actually being Medicare covered. And at the end of the day, we funded the set aside with $566,000. And the client was happy. The attorney was happy. They felt protected. They felt secure. And, that's really what we want at the end of the day. So I'm going to talk about structured settlements. A structured settlement, and I'm going to really focus on this in the personal injury context. We can use them in other contexts, but we don't have enough time. But a structured settlement is a series of payments made other than a single lump sum amount. It is a special type of investment that is just for people who are getting personal injury settlements. The benefit, structured settlements, some people do think they just have to be paid out monthly for a lifetime. We can do structured settlements monthly. We can do lump sums. We can mix monthly and lump sums. In some occasions, we can even just do a single lump sum. But the benefit of the structured settlement is the interest is guaranteed. It's fixed, and the interest in the growth gained is tax-free and it's guaranteed. It also helps to provide some spendthrift protection. And again, sometimes if we're doing a lifetime structure, we'll look at the rated ages, which really help maximize the value of that structured settlement. Cases in which, in the personal injury context, again, to consider structured settlements. And I think this is really important because a lot of people have talked to me and they think that structured settlements can only be used for catastrophic cases. And that's not true. And I think sometimes they provide significant benefits in the smaller cases. So cases involving minors, again, every jurisdiction has different rules as far as the minor settlements, but 9 times out of 10, doing a structure for a minor is going to be a lot better for them than sticking the funds in a restricted checking account or a Title 13 account in Maryland where they're not getting any interest. I adore my clients and they're wonderful. I've had clients message me and say, I have a minor getting $40,000. Is it worth it for you to work on this? And I say, it doesn't matter whether it's worth it for me. It is worth it for your clients, because if we can take $40,000 and turn it into $90,000 tax-free and guaranteed, you're going to have a happy client. Claimants requiring lifetime medical care, claimants who are no longer able to work. We have wrongful death beneficiaries, and I'm working on several of those right now. Those minors getting wrongful death settlements are very, very good candidates for structured settlements. And in that context, often the minor's not injured. So we're doing sort of a graduated lump sum program to help them pay for their college and maybe get started with buying a house or starting a business. And we'll design the plan like that. We can have sophisticated clients who just want to use the tax-free structured settlement as the conservative portion of their retirement portfolio, since again, it is tax-free. And then we have clients who just know that they need protection from themselves and from the friends and family. So when we are doing a structured settlement, in order to get these tax advantages, we must have the cooperation of the defendants in executing a release with specific structured settlement language, and we have to have the execution of a qualified assignment and release. The defendants have to fund the structure, so the structured settlement can't be funded from your IOLTA account. Because all this has to be wrapped up in the settlement agreement, I always recommend, again, once you start having some settlement negotiations, or you think your client might be a good candidate for a structured settlement, that's a good time to introduce the concept to them. Does not mean, again, we have to talk numbers, but let them know that this is an available option to them. See if they have any interest. So then if they do, they understand it by the time the case settles, then we can very quickly come up with a plan that meets their needs, and they already have that understanding and had some time to digest. So we can very quickly put the language into the settlement agreement, draft the qualified assignment, and get your case resolved. Cautionary tale. When you are accepting a settlement offer and you do think that your client may want to take advantage of a structured settlement, please advise the defense at that time that your client's considering placing a portion of their proceeds into a structured settlement, that they reserve the right to do so, and that the defendants will cooperate should the claimant choose to do so. Because I have had carriers who have just been awful, where, a settlement value was accepted, settlement offer was accepted, and the attorney did not at that single minute say, my client wants to structure. And then when the client makes that decision, the carrier says, nope, sorry, that was a material term of settlement. We didn't talk about it, and now we're not going to help you. Fortunately, not all carriers do that, but it does happen, and I hate that. It's really, really difficult. So again, let the carrier know early on. You don't have to let them know that your client is going to structure. You don't want to use the structure, obviously, to have them, you don't want the carrier to think they can pay less, but make them aware that this is something that your client might want to take advantage of. And so these are just a couple examples involving structured settlements only. So we have a minor wrongful death beneficiary, age 7, getting $197,000. So we set up a college plan, $15,000, paying semi-annually for 4 years for tuition. They would get $50,000 at age 23, $100,000 at age 25, $173,000 at age 27. And that was a total guaranteed benefit of $443,628. So in that case, the minor got $246,628.12 tax-free guaranteed interest. I did these examples are from cases I did earlier in the year. The rates in the past couple of weeks have dropped slightly. So, I can't necessarily promise that we could match these benefits now, but we're still in range and it still gives a good overview of where things stand. We have a minor automobile accident victim who was 12, getting $39,000 and change. In this case, we did a $35,000 lump sum at 25, a $46,000 lump sum at age 30, and then $81,000, which was a guaranteed benefit of $81,000. So that minor got $42,410 of tax-free guaranteed interest. Okay, and this is a case example, and I know might go about 2 minutes over before we go into the Q&A. But I worked with this amazingly lovely woman about 2 years ago, and she went in to go get surgery and sustained a brain injury that significantly impacted her motor function. It was right around the time of COVID. She got placed in this horrible Medicaid assisted living facility. She was only 49 years old. She had to look out the window at the hospital that caused her brain injury every day for years. She had 4 or 5 children. I can't remember. They couldn't come visit her because COVID. 2 of her children actually ended up getting jobs at this assisted living facility just because they really wanted to see their mom. So when she was getting her settlement, she desperately, desperately, desperately wanted to get home, buy a home, and be with her family. The life care plan there was $5,988,000. There was a mid-6-figure settlement here. And again, this was a Maryland case, so we are capped. This was a very, very good settlement. Client ended up with $2,550,000. And we know that is a lot of money. It can be, but it could go very fast if it's not used appropriately. So I wanted to just kind of talk about what we did in this case. So at the time, the client was getting $841 a month in SSI. That was the limit then. I have not confirmed with her that she is now at $943, so I just based it off of the benefits she was getting at the time of the settlement. So it was $841 per month in SSI. So we set up a special needs trust to protect those benefits. I set her up with a nurse case manager who met with her and said, I think you're going to be eligible for 6 hours of Medicaid in-home care. But this nurse case manager, this was really so critical that we got her involved early because she informed us that, under the various Medicaid programs in Maryland, if this woman stayed in the nursing home, or if she left the nursing facility and moved home before getting approved for home benefits, she would start on the waiting list, which was many, 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 many years long. If she could transfer the Medicaid program that was paying for her assisted living facility to the home program without any gaps, she would be in a lot better shape. So in this case, the nurse case manager said to the woman, you are going to unfortunately have to stay in this facility a couple more months. But during that time, we helped her find her a home that was safe for her and that was appropriate and that was at a good cost point for her. One that she would be able to navigate given her motor function issues, and that would be safe for her. And that, her family could visit or spend time in providing care for her. The nurse case manager, again, advised that she could get about 6 hours of in-home care provided by Medicaid. So the value of those services at that time were about $4,914 a month. So by doing a special needs trust, we added a value of $5,755 to her month. And like I said, it's over an additional value of more than $2,209,920 to the client over the course of her lifetime, simply by using a special needs trust. We did use a structured settlement as well as a special needs trust. And when somebody has government benefits, then we have the structured settlement pay into the special needs trust directly so that we don't jeopardize those benefits. So we put $850,000 in the trust up front to help with that home purchase, for the home modifications, for furnishings and liquidity. This was a few years ago. The housing prices were not what they are now. And so that was something that was realistic. And we came up with that number after figuring out what type of home would be most appropriate for her. We set up a payment stream with that structured settlement that would provide her with $7,830.30 for her life or 30 years, whichever was longer, starting 3 months after settlement. If this plaintiff lives 30 years or less, she'd be guaranteed to get $2,818,908 from that $1.7 million investment. The expected benefit, which would be if the claimant lived till the normal life expectancy of somebody her age and her condition, would have been $3,813,356. And if she lives beyond the normal life expectancy for a female her age, then she would be expected to get significantly more than that, because she has that lifetime annuity. Those benefits will not stop until she passes. And this is a diagram that I show to attorneys and clients to try to help them understand how a special needs trust and a structure work together. So here we have sort of the special needs trust is the bucket or the account that provides the guardrails and all the walls. We have the structure, we put an initial cash portion into the structure to help with some immediate needs and to provide liquidity. And then we use the structure payments to pay into the trust to help continuously replenish the trust as expenses get, taken out. Then outside of that special needs trust, the client can still get their SSI in cash and Medicaid. And then this is the MSA analysis of the case that I discussed in a little bit more detail. So you have the numbers there. And then for attorneys, again, we talked about some of the benefits. Attorneys do have options to defer their fees. They could do it through a traditional structured settlement annuity like your clients use, which is a fixed investment, but your interest will be tax deferred, not tax free. You can use, there's a product called iStructure, which is an index linked structured settlement. There's market-based options, and there's deferred compensation plans. And so if you want any more information on that, obviously I'm happy to talk about it. But I just, again, want to let you all know that this is an available tool to you. This also does need to come with the funding directly from the defense and language incorporated into your settlement agreements. All right. So, okay, I went 3 minutes over, but if anyone has any questions, feel free to put them in the Q&A or the chat, and we can go from there.
Yeah, thank you. So we are opening up the program for Q&A. Like Joanna said, you can type those into the Q&A section. If you're on a computer, that's going to be at the bottom of your screen. So at the bottom of the Zoom toolbar. If you're on a mobile device or a tablet, it's going to be up on the top of your screen. So we'll pause for a moment just to give people a chance to type those questions in. While we're waiting, I just want to remind everyone that your certificates of CLE credit and evaluations are sent out within 24 hours after the program ends. So you should expect to see those in your email, and we do appreciate any evaluations that you can send back.
It looks like we did get a Q&A. Yes, so somebody asked, do I help with smaller cases that involve Medicare or Medicaid, and what are my fees? I'm happy to help speak with anyone about any size case. With special needs trusts, if we have the type of Medicaid that does need protection with the special needs trust, there's something called a pooled special needs trust, which we can set up. If the settlement is over $20,000, then it would be a $1,500 setup fee for that. If it's between $10,000 and $20,000, then it is only it's a $1,000 setup fee. I'm sorry. And then if it's under $10,000, then it does not cost anything. If the client doesn't need a special needs trust and it seems like maybe an ABLE account is their best path, I would just advise you of that. And there's no fee for that. If it's a larger trust, we would end up putting that with, a corporate trustee. We would get an elder law attorney engaged, and then it would be more expensive. We can usually handle the smaller Medicaid settlements or smaller SSI settlements fairly inexpensively. And I never charge for my time or for my consults. It just sort of depends on what we're helping with and what type of product gets placed. And then as far as the Medicare is concerned, yes, we can certainly get involved in that. Happy to, bounce some ideas off of you. I work with a couple different nurse allocators. They have different price points, sort of depending on what you need. So feel free to let me know or offline me if you have further questions, and we can talk more about the pricing. But again, you're never going to get a bill from me for my time. So just wanted to let you know that.
Okay, thank you.
You're welcome. No?
Pause for a second and see if there are any other questions. If not, we'll wrap this up. Okay, well, it looks like those are the only questions we have at this moment. Joanna, is there anything else you'd like to say before I close this out?
I want to thank everyone very much for your time today. And if you have any questions, you can feel free to email me at jwynes@sagesettlements.com. It's JWYNES at sage, SAGE settlements with an S on the end.com. And I'll be happy to help you or provide additional materials. But thank you again, and I hope everyone has a great afternoon.
Okay, thanks. So that does conclude our session. I want to thank our speaker, Joanna, for her time, and thank all of our registrants who attended today's program. Certificates of attendance and evaluation forms will be emailed to live attendees within 24 hours. We do ask that you take a few moments to provide us with your evaluation of today's program. Our next Seminar Web Live program is September 26th, Effective Use of Demonstrative Evidence from Melvin Belli to the Present. I invite you to visit your association website for a list of more upcoming programs, and have a wonderful day. Thanks, everyone.